Hello and welcome to another edition of Coffee Talk with immigration attorney Brian D. Lerner. We're talking about S visas in this set of videos. Now, what about the S regulations and what about the discretion to grant the the S visa? What is looked at? Well, as stated, the application is filed on Form I-854. Now, uh, generally when it comes to my office, we prepare everything and then we send it to the LEA or law enforcement agency. However, you know, when it gets to immigration, it generally says the application is prepared by the federal or state law enforcement agency, and it must identify the state or federal court which the proceedings are pending and be signed by the prosecutor's office. The completed application is filed with the Assistant Attorney General in the Criminal Division, Department of Justice, who ultimately forwards the application to the appropriate authority within the Department of Homeland Security if he or she recommends it for approval. Now, as a practical matter, the review and processing of this form is handled by the Office of Enforcement Operations. So lots of different divisions here, but it is the role of the Assistant Attorney General to review the information and supporting documentation to complete and determine the completeness and accuracy of the petition. Now, the Assistant Attorney General will consider the negative and the favorable factors warranting an exercise of discretion on behalf of the foreign national. Now, often, this person, or the office reviewing it, will send the application back to the law enforcement agency or request additional information regarding negative information in the applicant's background or other questions about the case. The process can and usually does take a long time. You just have to be aware of that from the outset. There's no time frame for the processing of these applications, and they can actually remain pending consideration for years, which is unfortunate if you want the S visa right away. Now, where necessary, the Assistant Attorney General can submit the application for recommendation by an advisory panel composed of representatives of the Department of Homeland Security, U.S. Marshal Service, Federal Bureau of Investigation, Drug Enforcement Agency, and Department of State. Now, the function of this advisory panel is to prioritize cases in light of the numerical limitation, because remember, there's only 200 per year, and to determine which cases should be forwarded to DHS for final approval. Now, once all that's done, upon certification, the Attorney General can must forward the I-854 to Department of Homeland Security with all the supporting documents and a statement of all grounds of inadmissibility that apply to the witness and the reasons that a waiver should be granted of that ground of inadmissibility, including national security interests, and a detailed explanation of the nature of the cooperation and the government's need, the intended dates of stay in such status, and a statement that there is a number available for the S status. Now, final approval of the S rests with the appropriate immigration part of the Department of Homeland Security. Now, in the event that the application is denied, the Assistant Attorney General may object within 7 days, and in the event of an objection, the matter is referred to the Deputy Attorney General for final resolution. Now, just so you know, if it is denied, there are no appeal roads to go through. So if it's denied, that's the end of it. So you have to make sure you try as hard as you can to get it approved and to push it through. Okay, more on the coming videos.